Now back in session, Honorable Judge Simpson presiding.
You may be seated. Counsel, you've indicated emails between Hathaway and Parvis. What else are you looking for?
Thank you, Your Honor. And let me just apologize to the court. I know you took a recess, and I want to say I'm sorry. I did not mean to disrespect the court in any way. I apologize.
All right, folks, we're heading straight back into the courtroom action. The defense attorney just issued an apology for coming off as disrespectful, a classic example of when courtroom passion clashes with protocol. It's one of those moments where a lawyer's fierce commitment to their client almost steps over the line. Makes you think, how far can an attorney push before that passion backfires? Stick around to find out.
My arguments came across that, I would say, probably due to my extreme belief that my client is absolutely innocent. I apologize for my zealousness, making me feel that I was being disrespectful. I very much apologize. Other things besides that, Your Honor, communications between Will Hathaway himself and members of the prosecution team, including Parvis and Deputy Phillips, who's the officer in charge of the case. So that's what I'm asking for, communications. And I don't need to say anything more. I'll rely on my brief.
Well, no, I do have a question. How do I know these exist?
You don't. You don't. I only know what I've heard and what I've reported to the court. And what I was asking is for the prosecutor just to check. And maybe I misread his response. Maybe he was saying information belief means he checked. I just want to know if he looked and if there's nothing, then I'll...
Did you ask?
I asked for him and he said he wouldn't provide them. So they weren't discoverable during
Mr. Childers?
Yeah, and the problem, this is now like the third time in this hearing, as well as multiple instances in the pleadings, the defense is misrepresenting statements that I've made to the point where I don't feel comfortable speaking with the attorney absent being on the record or in writing. We've had phone conversations and somehow the subject of those phone conversations shows up in the pleadings, inconsistent with what was actually said. There was a statement in the pleadings that the fact that the defendant passes private polygraph, I should act upon it, even though I specifically told the defense attorney the only way we would do anything on the case is she pass the police polygraph, because
my arguments came across that, I would say, probably due to my extreme belief that my client is absolutely innocent. I apologize for my zealousness, making me feel that I was being disrespectful. I very much apologize. Other things besides that, Your Honor, communications between Will Hathaway himself and members of the prosecution team, including Parvis and Deputy Phillips, who's the officer in charge of the case. So that's what I'm asking for, communications. And I don't need to say anything more. I'll rely on my brief.
Well, no, I do have a question. How do I know these exist?
You don't. You don't. I only know what I've heard and what I've reported to the court. And what I was asking is for the prosecutor just to check. And maybe I misread his response. Maybe he was saying information belief means he checked. I just want to know if he looked and if there's nothing, then I'll...
Did you ask?
I asked for him and he said he wouldn't provide them. So they weren't discoverable during
Mr. Childers?
Yeah, and the problem, this is now like the third time in this hearing, as well as multiple instances in the pleadings, the defense is misrepresenting statements that I've made to the point where I don't feel comfortable speaking with the attorney absent being on the record or in writing. We've had phone conversations and somehow the subject of those phone conversations shows up in the pleadings, inconsistent with what was actually said. There was a statement in the pleadings that the fact that the defendant passes private polygraph, I should act upon it, even though I specifically told the defense attorney.
A polygraph test was offered, but the defendant turned it down. That's a big move. While lie detector tests aren't foolproof, passing one could have shifted the momentum in their favor. So why refuse? Is it fear, legal strategy, or something deeper? In the courtroom, sometimes what you choose not to do says just as much as what you do.
Need certain allegations against people that if I were to call you to task to say that that actually happened, I think you might be hard pressed to do so. The very fact that people with the same last name exist in an office doesn't mean that they had anything to do with it. In fact, typically, certainly as it would be between Patricia Reiser and John Reiser, I'll just say this, maybe what you're saying happened. Maybe. But the ethics of these individuals, if one's going to question them, then you better bring it. And not just try to float out that somebody did this or did that. Because, and I'll make it very clear, Miss Patricia Reiser has practiced in front of me for years. Known her for years. Her ethics are beyond reproach. The fact that I can tell you this and almost would bet my barker that if something came across her desk and it had to do with Scioto Township, and she knows that her husband is involved in Scioto Township, she'd have nothing to do with it. She would stop, it would go someplace else, she would forget about it and never have a conversation. That's who she is, that's how she's practiced, that is everything about her. So when I'm reading this, counsel, I'm going to tell you I have serious doubts when it starts that way. But things can happen. And that's why I went to the file before we got here to figure out who had it. She didn't have it. Her name's not on it. And I don't think it's fair to make accusations about people, offices, how they operate, without being able to substantiate it. You tell a story that somehow or another somebody, after getting done reading this, here's what I've got to believe. I got to believe somehow in Scioto Township, there is somebody who went to the sheriff's department, made some complaint that the sheriff's department then, without any basis whatsoever, then put together a report that they submitted to the prosecutor's office based upon their investigation, and that it didn't have, that there was no basis there to do anything.
Now this is a true courtroom mic drop. The prosecutor just called the conspiracy claims insane, a bold move that directly challenges the defense's entire narrative. The judge isn't letting it slide either, using this moment to emphasize how serious it is to make accusations without solid evidence. It's a clear reminder. In court, throwing out claims without proof doesn't just fall flat. It can seriously blow up in your face.
That then it got into the prosecutor's office, and the prosecutor's office then said, well, we don't see anything here, but we're going to make this happen. Wouldn't happen here. And that's really how your document reads. Go ahead.
I was going to say, I apologize that it reads that way. You have to, if you would just see it from my perspective, I'm coming into this case, I don't know Ms. Reiser, I don't know any of the players. All I know is what I'm seeing. And I see a woman who was part of essentially just an IT issue, and she ends up getting charged.
But counsel,
it makes no sense.
And maybe it doesn't make any sense. Maybe somebody made a bad decision in terms of their discretionary call. That's totally different from saying you shouldn't have done this to that there is this intentional thing to happen to charge your client. I'm having a hard time believing that. So while you may have absolute faith and belief in your client, which you should, that doesn't mean we create a conspiracy as to why something happened. Somebody may have made a bad call. Okay.
I 100% agree. I only wanted to give you the players and what their roles were. That's all I was trying to do, where people were and why it seems fishy to me. This case seems fishy, Judge, and I want to know if there's any shenanigans. I want to know if there's shenanigans in emails or texts between witness Hathaway and the sheriff. That's what I want to know. And if they don't exist, then the prosecutor can just say they don't exist. I guess that's what he's saying. So I'll take his position as, unless he wants to change it, as being, I've checked with the sheriff and these exculpatory documents don't exist. If that's the case, fine, so be it. That's the record and I will say nothing more. I appreciate the court's time today. And again, I did not mean to be disrespectful in any way.
So, because I'm not going to go through this again.
I don't want
Because, no, listen to me. You know, counsel, sometimes I want to just take attorneys back and just have them understand that in the privilege to practice law in this state, you need to be respectful of the process and the people. And you have to do it in a way that doesn't practice in a way that doesn't jeopardize your credibility. And I think people don't do that. And sometimes they don't do it with just the words they use. You know, Mr. Childers gives his response to your motion. I can tell you, I appreciate, I guess, Mr. Childers' discipline and how he responded, because I think if certain accusations had been made against me in my office, mine would have been a little bit more fiery than that. But that's just me. Do you have a copy of your reply?
I sure do. Would you like to? May I approach?
Boom. The judge jumps in to vouch for a key player's spotless ethics, going so far it's like they're staking everything on that person's integrity. It's a strong reminder of just how much character and reputation can influence a case, especially when the pressure is sky high. It really makes you think, when the spotlight's on and the stakes are up, how much can your reputation really protect you?
No, I've got a copy right here.
Oh, sorry.
I've got a copy right here. I want you to just follow along with me.
Absolutely, sure.
In your reply, that it's their 11th hour filing of its response to your motion to compel. Really?
Yeah, it was filed last night or yesterday. I filed it weeks ago.
What's the need to say that? I'm going to know exactly when it's filed. What's the purpose behind that, counsel, really? To say that somehow they were dilatory in what they needed to do and just sort of threw that in? I mean, really, what's the purpose in that? Then go to the next
Can I
paragraph.
just answer your question?
Go ahead,
The purpose
if there is
explain
one.
Why this was short and done in the last minute.
Counsel, I know when everything comes in. So, and then you make the pejorative statement in the next paragraph, counsel. That the people struggle